For those who don't know, my name's David Bell. I'm the Vice President of Bushwalking New South Wales, and I'll be sort of chairing the meeting tonight. Before I go any further, the issue of Gardens of Stone and the Master Plan and Plan of Management exhibition, there'll be something going out in the Bushwalking New South Wales next newsletter, informing people about the need to put in submissions and giving them the link to all the documents. So there will be some mention of that. So thanks for raising that, Keith. Welcome to all of you. This is one of our bigger meetings. It's a topic, I think, of great interest to many people. Firstly, Bushwalking New South Wales acknowledges the traditional custodians of country throughout Australia and acknowledges and respects their connection to land, sea and community. We pay our respects to their elders past, present and emerging, and acknowledge their custodianship of the country in which we engage our bushwalking and related activities. And at the moment, I'm speaking from Camaragal country, so welcome to all of you. Tonight's presentation by Christopher Birch is kind of the second part of a theme we've been going with since last year. You might, those who came to our meeting, I think it must have been about a year ago, we had James McCormack, the editor of Wild magazine, plus some other people from around Australia. We had some Tasmanians, and I think we had some people from the South Coast talking about this issue of development in national parks. So we learned a fair bit about what was going on, some unwelcome developments going on around other parts of the country. Tonight, it's my great pleasure to welcome Chris Birch, a barrister, Chris Birch S.C, Dr. Chris Birch S.C, a barrister, who is going to give his eminent legal advice and opinions and so forth about the whole legal framework in which development in national parks is currently underway or proposed. But I also should just make a note that for those who don't know Chris, he's quite a unique character because he's also an active bushwalker and cross-country skier. So he's actually a member of two of our affiliated clubs. So he actually, from that perspective, I think he's quite unique. He can obviously give us the legal expertise, but also he knows what the issues are, and he actually gets out into the wild country and can experience what we know and what we love. So tonight's meeting, for most of you, are Zoom veterans, so you'll be familiar with the opportunities to propose questions and comments via the chat function at the bottom of your screen. But what we're going to start off with is I'm going to run through a Q&A session with Chris, and I'm going to pose some questions to Chris, and then he'll give us his answers to these questions. They start off with more general questions about the legal framework that governs developments in national parks and the objectives of the National Parks and Wildlife Act. And then Chris will move on to the specific project down at Ben Boyd National Park, the Light to Light project. And Chris has actually done some research on this project as well. So we're going to start fairly general, then we're going to sort of zero in on the Light to Light project, which I know a lot of people are interested and have great concerns about. So, and after we've gone through with that Q&A with Chris, there'll be time for people to pose questions. You may find that some of your questions are covered by what in the Q&A session with Chris, but you may have other questions as well. And I know I've been sent a couple of questions from a couple of other people, which may or may not be covered in the first round of discussion. So we'll get round to those towards the end of the meeting. Okay, Chris.
David, good to see you.
Yeah, good to see you. Okay, the first question is, can you just outline to us the legal framework that governs developments in national parks?
Yes, it's actually quite complex. And of course, we're in a federation, so there's state and Commonwealth layers. But national parks are primarily a state responsibility. And as most of you would already know, the National Parks and Wildlife Act is the key statute that governs what happens in national parks. And for anything to happen in a national park, it, generally speaking, has to be something that's lawful under that act. But that is not the end of the story, because even if what is proposed is a lawful use of a national park, if it involves some kind of development, then there is almost inevitably the necessity for an approval to be given under the Environmental Planning and Protection Act. And that piece of legislation, it's the same legislation that affects you if you try to put an extra room on your house. is also what governs decisions about whether something is environmentally sound in a national park. So you've got to look at the National Parks and Wildlife Act, you've got to look at the Environmental Planning and Assessment Act. And we have a Commonwealth layer of regulation, but that is patchy depending upon whether Commonwealth power is attracted. So classically, if you're looking at a development in a World Heritage Area like the Blue Mountains, then there is at least potential for the Commonwealth to be able to step in if a development would impair World Heritage values. So a little bit about that later. The way that operates isn't quite as good as it sounds. And so the focus on developments in parks tends to be looking at, is it lawful under the National Parks and Wildlife Act? Is it something that's got appropriate approval under the Environmental Planning and Assessment Act?
Okay. And Chris, in relation to the National Parks and Wildlife Act objectives, how important are these to determining what development is permitted in a national park?
Sadly, not as important as many people might think. I've looked at quite a few submissions that have been put through, particularly, say, submissions in regard to things like light to light. And understandably, non-lawyers look at the objects and say, well, look, this is the purpose of a national park. How can they do something if it's not within the appropriate purpose? The answer, there are two answers. The lawyer's answer is that the objects and purposes in the Act are not generally strict restrictions on power. They guide the way that one should interpret the Act. But the more important practical consideration is that they tend to be quite loose in the way they're worded and often conflicting. So I'll just use an example. So one of the main objects at the beginning of the National Parks and Wildlife Act is to conserve habitat ecosystems, ecosystem processes, etc., which you would expect. But it's also to provide for management of the land reserved under the Acts in accordance with its management principles. And its management principles include, amongst other things, provision for sustainable visitor or tourist use, compatible with the conservation of the national park's natural and cultural values. Now, the problem one has is that those words are just open to so many interpretations, and the people in this meeting probably have some strong views about what sustainable visitor or tourist use, but I can tell you that they're probably very different to the views that would be held by those that like to develop eco-lodges and things like this. And so looking to the purposes of the Act doesn't get you very far when you're trying to work out whether something's a permissible development or not.
And what are the key provisions in the National Parks and Wildlife Act that limit the type of development that can take place in a national park?
Well, the pivotal provision is Section 81 of the Act, which limits the uses that can be made of the Act to what is permissible under the plan of management. And the plan of management itself has its own set of permissible purposes, which include benefits to local communities, and again, providing for visitor or tourist facilities and the like. So one can have plans of management that cover a wide span of purposes, but the crucial provision, Section 81, provides that after a plan of management has been adopted, then nothing can be undertaken that is not consistent with the plan of management. There was actually a proposal late last year to put in a new section which allowed the minister to override the plan of management, but that was taken out of the amending Act by a late amendment. So we're back to a provision which says the plan of management is what governs what may happen. And the plans of management can be very specific, and they can be remarkably stringent. So I pulled out the plan of, they're quite lengthy documents. I pulled out the plan of management for the Blue Mountains National Park, where I do most of my walking. And it provided that there wasn't generally to be any more tracks built in the park. Forget eco-lodges. They weren't even going to have anything much more than the existing historical walking tracks in the park. And so you look at a plan of management, you think that's fine. The problem is this, though. The plan of management can be altered by the minister virtually at will, and provided the plan of management is altered in a way consistent with the Act, then there's not much one can do to complain about it. There has to be 45 days public exhibition before the amendment goes through. The minister's supposed to do this on the recommendation of the head of National Parks and Wildlife Service, but that person is under the direction of the minister. So it's a somewhat circular limit. And we'll mention it later, but what happened with the light to light was the plan of management was too narrow to permit the new accommodation developments. So they simply amended the plan of management to permit them to take place. And if the government wanted to build a substantial luxury accommodation in national parks and the plan of management didn't permit it, then they would just say, oh, well, we need to increase accommodation for sustainable tourist and visitor use. And it wouldn't be very difficult for them to amend the plan of management.
And just sticking with the topic of plans of management, can you just go through the process for developing one?
Yes. All national parks are supposed to have one, and all the major national parks do. I didn't do a thorough website check to see whether there was some out in far western New South Wales that haven't got around to having them created. They're created often not long after the park has been declared. Many of them have been around for quite a long time. The Blue Mountains Plan of Management is relatively old, as an example. There's a 90-day public exposure period before a draft plan becomes a formal plan. And there's a process which I won't go into at great length set out in the Act for the creation of plans. But nearly all parks have plans, and the process of amendment is relatively streamlined. In other contexts where I've had to look at challenging management plans, there's been one approach that's been taken by government is to simply rewrite the entire plan and call it an amendment. And I have little doubt that they would do that tomorrow if they wanted to radically amend a plan. So you'll never have the 90-day period of public exposure. Almost any new plan will simply be treated as amendment. You'll get a shortened period of public exposure. And provided you can argue that the plan fits within the fairly general objects that plans are supposed to satisfy, then it will be difficult to challenge the plan.
And you've already covered this about the capacity of plans of management to restrict development, and you said that they may be highly restrictive, but basically there's ministerial discretion to amend it anyway.
Yes, so you might have a plan that at the moment looks really great, and you think, well, that's going to preserve all the values that we treasure. But if someone comes along and suggests to the government that it would be great to put a eco lodge or something like this there, then there's nothing to stop the minister saying, okay, well, then I'll just implement the amendment proposal, change the plan of management, and then there's no formal obstacle to me starting to embark on that process.
Okay. We might now move on to the light-to-light track upgrade. And how did all that come about?
Well, that was a classic example. I mean, the actual background is probably something that local people would know more about than me. But what happened was that in 2019, they proposed an amendment to the plan of management. And this was clearly an anticipation of then putting through a development application for upgraded lodges and accommodation. So they proposed a plan of management which would allow substantial change, the creation of the special eco lodge, I'll call them, accommodation at two particularly important sites. And that involved a process of consultation. I know the National Parks Association made submissions, but the submissions don't seem to have had any real effect on the nature of the amendment which went through. Once the amendment went through, the National Parks and Wildlife Service itself became the developer, so to speak, of the proposed construction. They had to get a second form of approval. They had to get approval, as I mentioned, under the Environmental Planning and Assessment Act, and they had to therefore produce a document setting out all the potential environmental impacts, called a review of environmental factors. And that was prepared in draft in the middle of last year. was published and available for public comment for a not very long, but I suppose period in which people could get some comments through. Now, that having all been done, we're still awaiting the final and definitive outcome of the application under the Environmental Planning and Assessment Act. And I haven't been able to find out whether that has actually resulted in an approval or not yet. There's nothing on the website for Ben Boyd National Park suggesting there's been an approval. And the last update on the light-to-light process shows in November last year that they were still considering. But what would happen next would be that there would be some form of approval given of the activity. The result of that would be that National Parks and Wildlife Service could do the building work themselves, and they've got government money, substantial money to do that. And they would own all those improvements. They would belong to the taxpayers of New South Wales. Then, having gone and done all that, they would be at liberty to then try and lease or license those facilities to a commercial operator. And let's assume that the proposal to lease or license takes place within 2 years of the approval under the Environmental Planning and Assessment Act. They would have to have no further public inquiry. Most probably, almost everything I say could be subject to legal debate, but that's, I think, pretty clear. And I think it's to be strongly anticipated that what will happen is that if this is approved, then there'll be a lease or license given to commercial operators to bring in groups of people. So they don't have to start with a private developer. They can build the facilities themselves, and then once they've done that, they can license them out.
So just to go back on that, Chris, if they decided to do that, did you just say that there'd be a 14-day period where people could comment?
If they were going to lease or license without doing any further building work, let's say they waited for 5 years and then they decided they wanted to lease or license it to a private operator and there would be no building work, then there would only be a 14-day minimum period guaranteed under the Act between public announcement of the proposal and closure of the time for public submissions. So the public would have to be really keeping a very close eye on the site to see whether they'd announce the intention to lease or license, and then they'd have 2 weeks in which to respond.
Right. In addition to restrictions under the National Parks and Wildlife Act, what other planning permission is required for developments in parks?
Well, this reference to the Environmental Planning and Assessment Act approval I've mentioned is really a procedural one. So and this might be one of the reasons why national parks like to do the building work themselves and then lease them later. When national parks exercises their own executive power to do the building work, then they don't need a development approval in the strict sense, the way you or I would if we wanted to renovate our house or build something new. But they need approval under under Part 5 of the EP&A Act, and under Section 5.5, there has to be an investigation into the environmental effects of the development. And it is, in one sense, a slightly peculiar provision because there's no actual test that has to be ultimately satisfied. They simply have to do the investigation. So there must be a determination by an authority that examines and takes into account to the fullest extent possible all matters affecting or likely to affect the environment by reason of that activity. As a lawyer, one immediately asks oneself, well, does this mean then that they could take them into account and examine them, decide that they were going to have terrible effects on the environment, but just approve it anyway? And I guess on one weird but literal reading of the legislation, that would seem to be the case. There's been a number of decisions, there's been a number of challenges that have attacked proposals on the basis that there hasn't been a proper examination. But all the ones that succeed simply succeed because there was a failure to actually examine rather than an examination, an identification of impacts, and then an approval despite that. So the only real restraint is this procedural restraint. Examine to the fullest extent possible, take into account, and then the authority has to decide whether to approve or not. I guess politically, it might be unlikely that some authority would say, well, we've found that there would be terrible environmental impacts, but we're going to approve it anyway. But the Act doesn't say that they can't.
And was this process followed in relation to light to light?
Well, that is the process that's being undertaken at this very moment. So the review of environmental factors was prepared as a way of trying to identify all of the type of environmental impacts that the proposal could have and ways of dealing with them. And it's a lengthy document. It's about 260 pages long, but I'll just make one little short point about it, because it goes to show that there are people with very different worldviews from those of bushwalkers. So we, of course, worry about the effects upon the wilderness and the landscape of these sorts of developments. The people identifying the impacts in their very lengthy review of environmental factors said the proposed accommodation and facilities would have a positive long-term effect on the environment by reducing the impact to soil stability through the removal of informal camping areas that currently do not have any facilities. And so in the eyes of those that were reviewing environmental impacts there, putting people in huts, for example, was a positively good thing for the environment because it stopped them pitching their tents all over the place and compacting the soil. So the review of environmental factors goes through and identifies, I have to say, it identifies an incredible number of environmental impacts. And so this is a way, I guess, of fending off challenge, because if one jumps up and says, aha, you haven't taken this into account, they will find somewhere in the 260 pages a passage that deals with it and say, yes, we've considered it. Now, that document is being considered at the present time by the Department of Planning, Industry and Environment. I think I probably got those words around the wrong way. Together with submissions that have been made on that that review of environmental factors. And so we're waiting for the outcome. So the outcome could be to simply approve everything that NPWS have asked for, or to partially approve it, or approve it subject to conditions. We'll just have to wait and see. And it could be that if the approval didn't impose any conditions and one could show the review of environmental factors really had ignored some important environmental impact, then there could be a challenge.
And just supplementary to that, Chris, why didn't NPWS go with an EIS rather than REF on this project?
The test for whether they have to go for an EIS depends upon whether there is a likelihood that it will cause, I don't remember the precise phrase, but it's something like significant environmental impact. So they have to decide that there will be a sufficiently substantial impact before they have an EIS. It may just be, though, a matter of words. In some of the challenges where authorities have produced a review of environmental factors and ought to have produced an environmental impact statement, they've said, well, look, they're the same thing anyway. Just cross out the word review of environmental factors and write the words environmental impact statement on, and it's treated as an environmental impact statement. So, and indeed, the review of environmental factors on the light to light is such a large and comprehensive document, it's difficult to imagine it would have made any difference what it was called. But there's a higher threshold before it's required. But though it's a higher threshold, it's met often in contexts that one would have thought had less impact than this. So you could challenge this on the basis that they didn't get an environmental impact statement. And I have no doubt the answer will be, well, what we did was in substance an environmental impact statement. And so a rose is a rose by any other name.
And you touched on the potential role of the Commonwealth law in relation to places like the Blue Mountains and World Heritage, but Did they, that this doesn't come, this isn't a relevant factor though for the, say, the Light to Light project?
No, I can't see that it intersects with the Commonwealth legislation at all. The Commonwealth legislation is very complex and extensive and covers not just World Heritage Areas, it covers National Heritage Areas, it covers Ramsar wetlands, and covers a number of other things. The Commonwealth doesn't generally have power over national parks. It gets power from things like international treaties to preserve the environment or heritage. And many of you will remember the famous Tasmanian Dams case, which upheld the Commonwealth's intervention to prevent the damming of the Franklin-Gordon River. So there's got to be some kind of special connection with the Commonwealth power. Now, I just don't think there's any in regard to Light to Light. No one's identified any. So I don't think there's any constraint other than that exists under state law.
Okay. So given all that, what can citizens do who wish to challenge decisions about developments in national parks?
Yeah, well, look, I'm going to be a bit of a bringer of bad news, I suppose, because it's a difficult thing to do. And what you have to look for is this, I guess. You ask yourself, firstly, is there power to do the things that they want to do? Is there some provision in the National Parks and Wildlife Act which says the director can do this in a national park? Couldn't build a block of flats or an office block, of course, but build a 3-story hotel, then it starts to become a very difficult question as to whether or not power exists. If one concludes that there is power to build some kind of tourist resort in a national park, the service still has to go through a series of processes and has to exercise that power lawfully. And so when you're challenging, what you're looking at is to see whether the power has been exercised lawfully. Was it consistent with the plan of management? If it wasn't, did they amend it? If they amended it, did they amend it by going through each of the legitimate processes, or was their amendment void and so they don't have power? It's a highly technical process. Often you look at a plan of management which might be 150 pages long. You look at a proposal and try to work out whether one can match up with the other. It's useful to use a few examples. There was a proposal up near Palm Beach by the local council to allow dogs to be walked on a beach. And the consequence of that would be that the dogs would go into the water, interfere with seaweed that was growing there and fish populations. And it was challenged. And the challenge was successful because the court found that what was being done was going to have an environmental impact and was therefore something that needed to have been assessed under the Environmental Planning and Assessment Act. And therefore, there had to have been an examination and inquiry under Section 5.5. And the council had just never even thought about these things. So they'd never done the investigation or inquiry. Therefore, they hadn't fulfilled a fundamental requirement, and therefore their rules that they'd made were set aside and declared void. So that was an easy challenge because council hadn't done absolutely anything at all. A controversial example, which falls on the other side, and something that those of us in the Nordic Ski Club have been very agitated about, is the removal of feral horses from the Snowy Mountains National Park. And in fact, there was a challenge to National Parks policy on the removal of horses on the basis that they hadn't acted in accordance with an appropriate plan of management, and they hadn't had a proper assessment under Section 5.5, because what they were doing was an extension beyond their plan of management. There was a plan of management that was reasonably old and predated the special legislation that gave the horses heritage value. The Land and Environment Court threw the challenge out on the basis that even though things had happened and times had changed, the plan of management was sufficiently general that it encompassed all of the activities that were then being undertaken. I suspect the court was keen not to embroil itself in what was a very bitter political contest as well. Let me just take the light to light, though, as an example, because we're getting very close to an approval, I suspect, which a lot of people might not like. What would one need to show if one was going to successfully challenge it? One would need to show, for example, that there'd been environmental impacts that would be inevitably produced by the proposal that hadn't been properly and fully examined and taken into account. One of the things that occurred to me was helicopter flights. There's going to be helicopter flights during the construction period to bring stuff in. And this is referred to in the review of environmental factors, but they said, oh, well, this will be a very limited period and they'll do it in such a fashion to cause minimal impact. But I couldn't find in the review of environmental factors, I haven't read every page, something which assessed, say, how many helicopter flights a year would be required to service the facilities and how they would be arranged so as to avoid impacting the peace and quiet of the place and not interfering, I suppose, with the cycles and lives of the animals that live in the park. So maybe it's not going to be very many flights at all, and therefore you're not going to get very far. But let's just assume that it turns out that it will actually be a very large number of flights and there'll be helicopters coming and going on a fairly regular basis. Well, then there might be a challenge on the ground that there'd been an inadequate examination. Problem was, with my reading of the report, I couldn't see anything that told me how many flights a week or a month or a year would take place to service the facilities when they were created. Maybe that's an inadequacy. But these are really matters of degree. If you're going to challenge something, you're not going to attract the attention of courts if it's too nitpicking. It's got to be pretty strong. And of course, sitting here now as activists, thinking about what to do, it's hard to make a call. How will we know how many flights they're going to be and whether it's something that really hasn't been adequately inquired into or not? So it's very hard. It often depends on trying to find a lever you can pull on, and that often requires you to do a lot of investigation in order to discern an impact, for instance, that hasn't been adequately inquired into. So far as the general question of eco-lodges is concerned, though, I have a fear that there is lawful scope for a far greater level of development in national parks than we are accustomed to in New South Wales. I think the reason we don't have luxury lodges and similar things in lots of parks and lots of places is more because the government to this point hasn't been interested in building them. But I suspect that that attitude is changing, and I don't see the pressure going away. I see it steadily increasing. So I think that there is going to be a lot of demand for this sort of thing. One is going to have to be alert to the proposals and review them, but one shouldn't assume that one's going to be able to block much of this through legal challenge.
I know in your notes you've given me, you do make a distinction, though, between national parks, or the national parks generally, but wilderness areas in particular. There's obviously a higher level of protection.
There is, that's right. In fact, in the notes I gave you, I may have referred to a challenge that was made. Many of you may recall some years back, there was a proposal to film in the Grose Valley. I think it was up near Mount Hay, and they were going to bring in helicopters and film an action movie or a scene in an action movie. This was objected to by, I think, the Blue Mountains Conservation Society, and it was a successful challenge. Then the ground of challenge was that the minister had given what was in effect a license to occupy a part of the land for the limited period they needed to film it. And the Wilderness Act prohibited any leases or licenses in declared wilderness areas. In fact, a declared wilderness area is still very strongly protected. So there are, of course, substantial parts of the Canangara Boyd, there's the Jagungal Wilderness, there's quite a number of wilderness areas which are protected. In fact, in the light-to-light review of environmental factors, they make note of the fact that it's not in a declared wilderness area. I wondered to myself, how would you get around that if you're a minister? The minister can amend the areas of a declared wilderness, and the minister's amendment doesn't require a step to be taken by way of legislation, but it is capable of being disallowed by the Parliament. But if the minister wanted to revoke a wilderness declaration in its entirety, it requires a vote of both houses of the state parliament. So wilderness areas, a declaration of an area as a wilderness area is a strong protection, but not a complete protection, especially if it was, say, on the fringe of a wilderness area. There'd be scope for the minister to try to amend it and cut a slice off where they wanted to stick their development.
Okay, thank you. And is there a preemptive strategy, having said all that, that we can take?
Well, there's a couple of strategies, I suppose. Concerned citizens have a general right of standing to go to court to seek injunctions to restrain breaches of either the National Parks and Wildlife Act or the Environmental Planning and Assessment Act. And that's what was done successfully in the Gross Valley case by the Blue Mountains Conservation Society. But those challenges depend on this hard test. You've got to show that what's being done is unlawful, that they're breaching the act. It's not enough to show that a discretion that was exercised might have been exercised better in a different way. Lawyers refer to so-called merits review, where you can go ahead to a court and ask them to decide the thing all over again on fresh evidence. And you don't have merits review rights generally if you're just an activist. You've got to show there was a real breach of the law. And you've got to move quickly if you are going to make these challenges. If the approval for the light-to-light comes out tomorrow, there won't be a long time to sit around wondering about whether or not to challenge it, especially as they've got builders ready to start work. In my notes to you, David, I posed the question as to whether or not the bushwalking movement itself has to think about just how to meet the demand that is going to come. The legislation will allow governments to build substantial numbers of luxury lodges in national parks if they're determined to do it. But the plan of management is still a major constraint, given that the proposal to allow the minister to overrule plans of management was disallowed. And so I asked, should we be pulling these plans of management off the shelf preemptively, studying them carefully? Should the bushwalking movement itself come up with its own suggestions for a middle path somewhere between the luxury lodge option and the nothing at all option? Those of you who've, say, walked something like the Larapinta Trail will have seen what I think is a really brilliant trail marked with some very basic facilities, and yet still very, very popular. People come from all over the world to walk it. Should the bushwalking movement be advocating for some kind of limited minimal developments? And should they try to work out what they should be now and advocate for them, in a sense, to try to occupy the space before some developer proponent comes in and starts a debate about their proposal rather than a proposal put forward by the bushwalking movement?
Thank you, Chris. That's all good thoughts to ponder. And we hopefully have a bit of time to come back to those. But I've got a number of questions from other people. In particular, I'm going to start with, I've got questions by a fellow called Mick Rippon, who some in the audience may know of. I don't think he's here tonight, but he put 4 questions. He's actually from the Fishing Alliance down south, and he's been very involved in the Ben Boyd proposal. And there are 4 questions he's presented to me, one of which is a more general question. So I'll start with that. The other 3 are more specific to light. He asked us the question of social license. Does it carry any weight in the legal sense? So he says when the government says it's consulted the community, but the community has overwhelmingly rejected the proposal, is this a violation of the social licence process? And if so, is there any legal course of action?
The short answer is no. I don't recall the phrase social licence appearing in public debate until it was used by Michael McHugh, the retired High Court judge who conducted the inquiry into greyhound racing in New South Wales. And he said that if the ordinary citizen knew how dreadful and outrageous the conduct of the industry was, they would take away its social licence. But what he was talking about was through, I think, political action. They would simply demand that it be stopped. And lying behind that was, of course, the idea that certain conduct is so despicable that ordinary citizens would almost all agree that it had to stop. One of the problems that I think we have is that there's a lot of difference of opinion about what is and is not an acceptable development in national parks. I conducted a quick poll on my colleagues this afternoon, and there were many of them that thought the idea of luxury lodges in national parks was a fantastic idea because they couldn't imagine anything as awful as camping. So I don't see that I don't think we're going to be able to run social license campaigns, and we're not going to get traction in courts with that point.
Okay. His next questions relate specifically to light to light. And the first one is that his understanding is that the 2010 Plan of Management Amendment for Ben Boyd and the Bellbird Creek Nature Reserve did in fact allow for hard-roofed or soft-roofed accommodation at Murray Point and Batangabi Bay. But obviously the more recent amendment, Plan of Management Amendment, allows construction of accommodation at Hegarty's Bay and the modification of accommodation at the Lighthouse. If the current proposed Plan of Management changes fell over, would the government still be able to construct hard-roofed accommodation at Murray Point under the old 2010 Plan of Management?
Probably not, in part because I have not looked at this directly, but I suspect that old Plan of Management simply wouldn't have encompassed the sort of level of development envisaged by the proposed accommodation that's being put forward, which has got a lot more support and facility to it than what may have been originally contemplated. But I don't see any of these Plan of Management amendments falling over, I've got to say. It's not that hard to amend the Plan of Management. And so I think that, they could, technically you could amend the Plan of Management every year if you wanted to.
Yeah. His next question, I think you've already covered this in your previous comments, Chris, was about the objects within Section 2A of the National Parks and Wildlife Act. And I think, people shouldn't be allowed to do that in a national park, because it's impact on natural areas. But as you said, you colleagues have varying opinions about what's acceptable in a national park. He does make a comment, which I'm not personally aware of, but you may have heard of. He refers to a development proposal for Wilson's Promontory in the late 1990s, which he sees as similar to the current Ben Boyd situation, which I believe was some sort of tourist developments in Wilson's Prom.
Yes, and Kirsten forwarded on to me an article which I think was referred to by that person. And that was a very interesting article about proposals to build quite luxurious accommodation in Wilson's Prom. At one stage, they proposed, I think, a 3-story hotel, and then they had proposed some various lesser developments in other places. Most of this fell away, but one wonders whether it may come back. But it reminded me when I read it, because they backed off very quickly on the 3-story hotel, but they kept pushing for quite a while on some of the other accommodation. It's, of course, a standard tactic in the world of development to put forward something fairly outrageous at the beginning and then back off the more outrageous aspects of it, and everyone heaves a deep sigh of relief that we didn't get the really outrageous version, we only got sort of toned down version. But often the toned down version was what was really being aimed for all along, and the outrageous stuff was just put in there as a kind of decoy, so to speak. I can just seeing development proposals where there'll be 2-story or 3-story accommodation, and then they'll back down to 1-story.
Yeah.
But I mean, yes, Wilson's Prom have been down that path. Of course, in other places, I mean, the Cradle Mountain Walk, which is so famous, and many of us have probably been on it, has huts which get regularly upgraded and expanded in size. New South Wales has just never had anything like that, but it looks like it's coming.
And his last question, I think you've already covered, was about the role of the Department of Planning, Industry and Environment in the determination of the proposal. But I think you've already covered that in the relation to how the legislative framework.
Yes, it's a dual process. There must be authority under the National Parks and Wildlife Act and approval under the Environmental Planning and Assessment Act.
Yeah. Thank you, Chris. Look, I'm now going to go to the chat box, and there's a lot of questions here. And unfortunately, I don't think in the time available, we're going to get through them once. So I'm going to pick, probably unfairly, but hopefully it's reasonably randomly, some questions. Someone's raised a good point about the severe bushfires in the park through 2019 and 2020, and whether that, in terms of a lot of the environmental impact assessment for the project was done prior to that, and whether in fact the impacts from the fire should have forced them to go back to the, so to speak, to the drawing board and reconsider the whole environmental impact process again from the start.
Well, that is indeed possible. In fact, there's even legal authority that the inquirers and examiners have to consider things which arise after the original proposal, even if they weren't in the initial surveys or impact statements. So it's, you can't say at time T1, this proposal was put forward and we ignore everything that happened after T1. You have to take into account everything that happens right up to the point at which you give the approval. But on the other hand, you've got to really show that there was, I mean, there's a lot of consideration of bushfire danger and bushfire problems in the, say, the light to light thing. You'd have to show that there was something that was qualitatively so different that they'd failed to undertake their task of proper examination.
Right. Someone's made reference to the fact that the Hegarty's Bay campground has been closed since 2020. The road to Murray Point's been closed since December 2021. Both locations where accommodation complexes are planned to occur. The question is, if the approval hasn't happened yet, how can they be doing all this stuff on the ground?
Yeah, it's funny. Good question. When you go to the website for the national park, it speaks about this as if it's all a done deal. And so far as I can tell, it just isn't. I mean, technically, the authority could just turn the whole thing down. It seems improbable that that would happen. And buried in the fine print is usually something to the effect that, of course, it's all subject to approval. But they do seem to be very gamely proceeding as if the approval is inevitable. But it's not. And I suppose as national parks are the people doing the work, and it is kind of like their park in a sense, they can always do a certain amount of fiddling around with roads and access and things like that, just as a part of their ordinary management power. Maybe that's what they justify.
There's another question here, which is about the independence of the people who write the environmental impact assessments. And I know this is a question that gets asked lots of times about the independence of people who are basically consultants who are doing the work. And it's just suggesting is that the danger that they'll provide a favourable report to what the client wants.
Yeah, I think it's a conflict of interest. I mean, it's the same with private certification in the building industry. We've discovered now what happens with private certification. We now have a disaster on our hands with multi-story residential buildings that are unfit for use. And part of this is a result of the fact that they privatize the process of certification and the developer hires his own certifier. Here, the proponent of the development hires their environmental assessor, and no doubt the environmental assessors will protest that they do the job in good faith. But it's odd though, because there are so many other areas of life in which if you were paid in that fashion, you would not be seen as independent. I just think it's a problem. And I think that one way of improving things would be to agitate for the creation of a system where the assessors are paid out of some kind of fund and not chosen by the proponents, so that they're fully independent.
Moving on to a different topic, I've got a question here. Is the New South Wales National Parks Act different to the Tasmanian National Parks Act? Because we're obviously seeing a lot of these tourist developments happening in Tasmania. Is it a different legislative framework that's allowing these sorts of things in Tasmania to get more easily through?
Yes, every state's legislation is different. It's a completely different framework. And in fact, although I haven't sat down and done a comparison, I don't think you'd find that they even follow a basic template. I'm sure that there is very substantial difference from state to state. They're state-based laws, and every state's laws are the result of the political horse trading that's gone on in that particular state.
Right. There's another person, this is more of a comment, but they're referring to the fact that the DPIE in their summary of the submissions made on Light to Light said the high number of submissions was due to great interest of the community rather than the vast majority rejecting the development. So it was sort of just, they're twisting words to say, oh, everyone's interested in it, so it's good that we got all these submissions, but they haven't touched on what most of the submissions actually said about the development. So that's more of a comment.
Can I just say in regard to consultation processes, they're very common in legislation, and they're usually very loosely defined, and governments go through these processes, and they've often announced in advance they're going to do things, and they also say that they will consult with the public. And it strikes me as wrong to both simultaneously announce you're going to do it and say that you'll consult. I was involved in the council's amalgamation litigation, and there were very broad requirements to publicly consult, and they publicly consulted, and almost everyone was against it, and every one of the proposals went through. It's just most unfortunate.
Yeah. There's another comment here. Actually, it's from James McCormack, who I can see in the audience. When you mentioned about the helicopter flights to fly in materials, building materials and stuff, he said there were approximately 17,400 helicopter flights to build the Three Capes track in Tasmania. So this sort of thing could be incredibly substantial in terms of its impact.
Yes, the way they respond to it in the review of environmental factors is to simply say that it'll be a short-term thing, so we'll live with it and it'll be all over. But if you look at places where they have very luxurious lodges that are serviced on a regular basis, it can be significant. I was at a lodge in New Zealand some years ago, and we had a big sort of wild night on the last night of the walk. And when I was walking out, a helicopter was coming up the valley, and I was told it was going to replace the cellar that had been drunk dry the night before. And they don't seem to have too much trouble in New Zealand flying helicopters back and forth all the time. But it rather spoils the ambience, and it ruins any kind of wilderness value. Yeah. And if they're going to service lodges like that.
Yeah. One of not a sort of side issue, but you'll be aware of the proposals in the Alpine precinct in Kosciuszko, and one of the ideas that the master plan comes up with is this flying visitors in by helicopter from Jindabyne or Coomera or whatever into the Alpine precinct. I mean, that's just another example of potential terrible impacts from helicopters flying over wilderness areas.
Yeah, no, I think helicopters are dreadful things. Nothing quite ruins the feel of being out on a bushwalk like having a helicopter come over the ridge line. And so, I mean, you put up with it occasionally, but once it becomes a regular thing, then it's spoiled a large part of what we're there for.
Yeah. A couple of more comments, and this actually touches on where you ended with your comments about the future of these long distance tracks and et cetera, but the comments made that the state government has more than 450 million proposed to be invested in more than 200 visitor infrastructure projects across the Park Estate, including 10 multi-day walks that use a combination of on-park and off-park accommodation. And Keith Muir has just made a comment about the Wallamai Great Walk, which is mentioned in the Gardens of Stone Master Plan, is I think one of these. We've been trying to find out from the government the full list of these 10 projects, and we've got about 5 or 6 nailed down, but there's a number still under the surface we're trying to extract from the government. So all of these ones, these 10, I think they call them the Great Walks, and I think the Wallamai one's been badged as a Great Walk, but we're very concerned about the potential for on-park accommodation, luxury accommodation.
Yeah, well, I suppose that it's crucial to keep one's eye out for proposals to amend plans of management, because that's obviously going to be a first step. But I noticed checking the Ben Boyd National Park website this afternoon and the Light to Light Walk upgrade site, there was a list of 10 projects of which this was said to be one. I don't know whether that's the list of 10 you're after or whether that's another.
No, it is. 10. It probably is the 10. So I'll have to chase you up for that reference. Was that in Ben Boyd, the Ben Boyd website? I'm
pretty sure I was at the Ben Boyd website, but they had a special Light to Light upgrade update, and it was in.
Oh, yeah. Okay, we'll check that out. Someone makes a comment about what's happening in Queensland at the Great Sandy National Park, where Queensland National Parks are proposing private cabins at Lake Poona, which I think I've been to. It's a perched lake. So these things are sprouting up everywhere. Let me see. Someone makes a comment about a huge issue of social inequities and access based on affordability. And they refer to the Spices Scenic Rim Walk, which is in Queensland. 6 days, 5 nights for over $10,000 a head. It's interesting. One of the rejoinders we get from national parks in relation to things like Light to Light and other projects is they say, well, we're opening the parks up to other people who would normally not visit these parks. So they say, well, you bushwalkers just want to keep the places to yourselves. And it's a rejoinder we've had more than one occasion from people in government saying that we're being selfish.
You're going to hear it over and over again, I suspect, because it contains at least this truth that there are lots of people who don't want to camp. Certainly, they don't want to have to sort of do the kind of rather tough camping that we're accustomed to. And so it is true that it gives a kind of access. I mentioned my arguments with my colleagues this afternoon, and I said, well, look, there are so many places you can go to where you can stay in luxury accommodation, and there are so few places I can go to where I can camp in what is truly a wilderness, that I don't feel that we've got more than our fair share. We've got, if anything, less. And I think that might be an argument that needs to be made forcefully at times, because ultimately the way some movements are going, we'll end up with nothing. But maybe the bushwalking movement needs to also identify what might be called the crown jewels of wilderness, so to speak, to sort of preemptively say, well, look, these are the sacred places. So if you're going to build luxury accommodation, don't build it in, the Canangra Boyd wilderness or the Jugunga wilderness or whatever, but maybe stick them on the edges of somewhere that's less precious.
Yeah. Good. Look, I'm going to apologise. I'm going to close this off now, and I apologise to everyone who I didn't get round to their question or comment. But Kirsten, a lot of people have put in some quite useful links. Can we sort of send them out to everyone?
Yep.
Is easy way of doing that?
Yes.
I just thought people have been very generous in providing all sorts of links about primarily Light to Light, but other things, and I thought that would be useful to other people.
Yep. Okay.
All right. Thank you. Look, thank you very much, Chris, for that. That's been extremely informative. One point I do take from you is that we need to be very vigilant about plans of management and actually actively reviewing them. I don't know whether I assume there might be many hundreds, but we need to sort of come up with a priority list of plans of management in places where these sorts of developments are likely to occur.
Yes, I think that's a very good idea. I think we probably, I've been bushwalking the Blue Mountains for a long, long time. I only started looking at the plan of management a few weeks ago, and I was a bit struck by what I saw, actually. It sort of was very restrictive about some things. I thought too restrictive, and other things less so. So, yeah, it's definitely a good preemptive measure, I think, that we get on top of these and know what's actually in them.
Speaking of the Blue Mountains, and I think this is information for everybody, but National Parks is actually updating the plans of management for Blue Mountains and Canangra Boyd. And they had some community meetings last year. And I think my understanding is the drafts will be emerging sometime this year. I think it's terribly important that everyone in the bushwalking community gets into that process and reads these drafts and makes comments, individuals and clubs and so forth. I think everyone needs to get really on top of that, because I think I mean, I don't know what's in the detail of what's in them, but it's obviously such an important area for bushwalkers. And I think this plan of management, which may be setting the direction for the next 10, 20, 30 years, I think we really need to get onto that. Yeah. Look, I'm going to call Chris's presentation to a close. Thank you, everyone. We do have some bushwalking New South Wales business, so we do encourage people to hang around for that. Kirsten, we got a prize to give at the end?
No, unfortunately, we don't.
Oh, there we are. We're letting you down. What we normally do, I did omit to mention, we normally cover the
Sorry, Dave, can I just interrupt? I'm happy to give a prize of a annual subscription to Wild if you choose whoever gets it, but I'm happy to give a subscription away for the year.
We usually just go and randomly pick a number.
Okay, pick a number and just let me know the number and we'll get it.
And Kirsten can decide which number it is.
Okay.
Yeah.
I'll nominate the number. I'll say the number is 37.
Okay, 37. So, I'll have to.
As long as it's nobody on the management committee of Bushwalking New South Wales.
Or me.
We've got to keep things above board.
Okay.
Does that make sense, Kirsten? All right.
I'll come back to you on that one. 37.
All right. Good.
I'll work on it.
So good. Thanks very much, James. Just some Bushwalking New South Wales business. We would normally sign off on the minutes from the previous general meeting. Unfortunately, we didn't get round to actually putting it anywhere where you could read it. So that would be unreasonable to ask you to approve something you haven't had a chance to read. So the next general meeting will be signing off on 2 sets of minutes. The last one and the minutes for this one. So sorry about that. Kirsten, we normally do a bit of a club roundup.
Yep.
So anyone from any of the clubs has got anything to update us on? Now's your chance. Paul McCann, I can see you're hiding there. You can actually put out your comment about getting some assistance with website development. You can ask someone from another club if they can pick up the phone. You need to chat to them. Paul, you're on mute.
Yeah, okay, yeah. Actually, you cut out in the middle of that statement, so I didn't quite hear what all you said.
You want some assistance on making your website better, your club website. So there might be another club out there who've been through this process and can give you some help. It's just a matter of getting on the phone to somebody.
Yeah, I saw one person there earlier, but
if there's anyone whose club's been through a website upgrade recently and may be able to help out the Armidale Bushwalkers, drop a line to Kirsten and then she can forward your details to Paul.
Yeah, that sounds like a good idea.
All right. Okay, good. Any other news from anyone else? No. Well, Kirsten, I think all that we need to do is draw the prize.
Okay, cool. So I have found the winner and it's Anne Wicks.
Oh. Here we go. There we go. Congratulations, Anne. So your subscription was coming your way. Anything else, Kirsten?
Nothing from me. You did mention that everybody would like people to look at the Gardens of Stone plan of management and comment on it.
Yes, and also the other one that people might be interested in is there's a plan of management on exhibition at the moment for the Southeast Forest National Park. It's an amendment to the existing plan of management. What's interesting about it is two parts to it. One is there's a rewilding proposal where they want to reintroduce animals that are locally extinct. They want to reintroduce them into the park. Obviously, feral animal control is pretty crucial to that. But the other thing they want to do is develop a couple of low-key campsites and mark out a route for the thing called the Bundian Way, which is a culturally significant Aboriginal pathway from the Kosciuszko region down to the coast near Eden. So this bit of the Bundian Way would be the bit that's within the national park. So it's not the whole route. Anyway, I think that's a positive development, and obviously, hopefully the Indigenous communities heavily involved in that as well. But so there's, for those down the Southeast Way, that's one that's currently on exhibition on the National Park website. And as Kirsten mentioned, the Gardens of Stone Master Plan and Plan of Management amendments are out on exhibition at this moment, and submissions close on July 5th. So we urge you all to make submissions, both at club and individual level. But if you have any comments that you'd like Bushwalking New South Wales to address in our submission, then send them through.
Excellent. Thanks, David.
Okay.
The other thing I could mention is the Great Escarpment Trail.
Yes.
That's now been fully mapped. So if anybody's interested in doing some walking between Barrington in New South Wales and Boonah in Queensland, we'd love to hear from you, get your feedback on what it's like to walk the Great Escarpment Trail. We've fully mapped it and it's ready for you to go out and ground truth, and there you can win a prize just for the photos and feedback you share after ground truthing. Now I see Caro Ryan has her hand up. So Caro, did you have something to add? Maybe not.
Someone said...
Is Caro on mute?
She may not hear you.
On mute.
Looks like.
There she is. I've just following up a couple of things earlier. Someone said the Coffs Harbour Bushwalkers have a good website. So there you are, Paul. You can check them out.
Yeah.
And actually, coming back to Chris, someone's got a question about getting legal assistance. Dave, do you know of any alternatives to the Environmental Defenders Office? Because I think they've approached the EDO and they basically don't have the resources to take on Light to Light. Could you suggest anything else? And Chris, you're on mute.
Yeah, sorry about that.
That's all right.
There are always lawyers out there that are willing to run a public interest case. The hard thing is a filter mechanism, because I can't put aside enough time to go through all the people who would like me to run their public interest cases for them, because I could spend my entire year doing that. And tragically, most cases have got no hope. So what you need to do is to find some lawyer, local solicitor or whatever, who's able to have a look at it, and if they think it's got a chance, then get on to someone like me and I can have a quick look at it. And if you've got a case that's got legs, as we say, then you can usually find some lawyers, but it requires you to sort of get someone to do that filtering, because I can't sort of say, yeah, I'll look at everyone who's got a public interest case in New South Wales and run it if I think it's going to work. I'd spent so long at cases that have got no chance. I wouldn't be able to do anything. So anyone who's who can sort of get a local solicitor or whatever involved is going to be on the road. The EDO, even if they won't run it, they may be able to sort of identify some issue, and then they can contact someone like me and say, well, look, we've filtered it this far. This is possibly where it could go. What do you think? I know it's a bit vague, but it's a tricky process. But if you've got a real case, which is a runner, then usually you'll manage to find a lawyer.
Thanks, Chris. I think we might close the meeting.
Oh,
at that point,
sorry.
Unless, Caro, there she is. She's waving. Yes, Caro.
Oh, is my microphone working now?
It is.
Yes.
I can hear you.
Hallelujah. I know. First of all, I noticed that Zyra, I think, had her hand up too before me. So I don't know if she's still in the room and had a question.
She was having an issue with her audio, so I don't know whether that was still a problem.
Okay, it might be catching.
And then she says, no, all good.
Oh, okay. So I just unprofessionally was going to talk to Kirsten while you're all listening in to say would now be a good opportunity for me to raise that thing we've been chatting about on email today with the videos.
Absolutely. That sounds a great idea.
Excellent. So over the next week or so, we're going to be calling for testimonials from members and leaders in particular, people who lead walks and even lead within other capacities within their clubs. So you might be involved in, even like Paul said, like in the website development, you might be on the committee helping put the walks program together. You might be on the conservation secretary, getting involved in campaigns like we've been talking about. Looking for testimonials, short video testimonials from all different clubs around New South Wales that will help go into these new videos that we're putting together to help people get involved in the management of their clubs. So there'll be a full brief and a really simple instructions on how, like a bit of a how to do it, and the file format that we're going to be looking for. So it's going to be on video. So just sort of maybe start thinking about someone in your club who might be great to do that kind of thing, to give us a little short testimonial. I mean, short, like, 30 seconds kind of thing. Who could help contribute to these videos that we're putting together for Bushwalking New South Wales. So I think that's about it, isn't it, Kirsten?
That is it. That's very good. Thanks, Caro. And I'll be sending through some instructions from Caro. So it'd be great if people could do their little video.
Thanks, Kirsten. And thanks, everyone. We appreciate it.
Thank you, Caro.
Thanks, Caro. Well, if there's anyone else going, I would like to thank Chris very much for his presentation, and we'll have to get you back on some other matter sometime in the future if you're available. But thank you very much for that. It was really, really worthwhile. And thank you all for joining us tonight. And there's obviously a lot more work to be done. So see you around. Good night. And thanks, Kirsten, for setting it all up. Okay, good night.
No worries.
Night, everyone.
Okay.
Bye. Good night.